I'd like to call to order the June 14, 2016 Finance Committee meeting. You can have a roll call, please.
Mr. Chairman, Mr. Netto. Anthony Netto.
Here.
Mark Finkel.
Here.
Albert Hayes.
Here.
David Bergstresser.
Here.
Jeffrey Rosenthal.
Here.
Robert Moore. Excuse me. Robert Smullen.
Here.
Robert Leslie.
Here.
Robert Fulton.
Here.
John Hodgson.
Here.
Stephanie Rizicki.
Here.
Richard Farrar. Mr. Chairman.
Thank you. And at this time, I guess we need a motion to adopt or revise the meeting agenda.
So move.
All right, I'll second that. All in favor?
Aye.
Opposed? None. All right, and then also a motion to approve the March 1st, 2016 Finance Committee meeting minutes.
I make that motion.
I'll second it. All in favor?
Aye.
Aye. Any opposed? No? Good. So the new committee business for today, there's 3 items. First of which is we're looking to advance to the full board and recommend an adoption of the July 1st, 2016 through June 30th, 2017 Hudson River Area Assessment. And if there's any comments by staff, we can take them at this time.
Mr. Chairman, on page 11 is my memo to the board regarding the approval of the annual watershed and state assessment for the Hudson River area. Resolution is on page 12. The assessment sheet, cover sheet is on 13, and the actual assessment schedule is on page 14. As the board is aware, Title 21, Section 15, 2123, and 2125 empowers the board to annually prepare a statement showing the name of each public corporation, description of each parcel of real estate benefited by such reservoir, in this case Sacandaga, and the amount of operation and maintenance charges to be borne by each determined in the apportionment. This apportionment is obviously not changed, and the assessment only change this year is this is the first year now. We are in the second year of our 3-year cycle where we are now including Saratoga in the assessment, or we're not doing the property tax swap, I guess. Unless the board has any questions, I recommend the board approve this assessment for, do we have separate resolutions? Yes. For the counties, which is $2,994,100, and for the state share for the same period, for the second year of the budget ending June 30th, 2017, the state's share is $853,922. Mr. Chairman.
All right, thank you. So at this time, I'll request a motion to advance to the full board for adoption of the July 1st, 2016 through June 30th, 2017 Hudson River Area Assessment.
I'll make that motion.
I'll second it. All in favor?
Aye.
Aye. Any opposed? No. And then secondly, we already touched on the state share, so I would request a similar motion to advance to the full board and recommend adoption of the July 1st, 2016 through June 30th, 2017 New York State share in the amount of $853,922.
I'll make that motion.
I'll second it. All in favor?
Aye.
Aye. Any opposed? Okay, thirdly, new business. I think it's just more comment than anything, the status of the Black River area reapportionment. I see there's possibly 3 speakers to that. Mr. Farrar, do you want to start that?
Sure. Last, I believe it was, and the chief engineer can refresh my memory, I believe it was March or April, we issued the board an initial memo addressing the board's wish that staff initiate an apportionment for the Black River area. That current memo begins on page 18 and ends on page 21. Covered several different areas, identification of the benefit derived, identifying the beneficiaries, proportionate benefit methodology and calculation, and I believe that is the area that is new to this memo, and I would ask Mr. Fulton to discuss that
Certainly.
new component.
Beginning on page 2 of the memo, with the heading "Proportion of Benefit Methodology and Calculation," that segment of the memorandum is new and new. The remainder of the memorandum remains unchanged. As Mr. Farrar mentioned, we had previously identified benefit derived as well as identified beneficiaries. The beneficiaries being the approximately 29 hydroelectric facilities and the 5 counties that comprise Black River area adjacent to the rivers, which are regulated. The section of the memorandum, which is new, methodology and calculation, describes staff's proposed proportion of benefit methodology, which reflects the proportion of benefit derived by the hydro facilities and the proportion of benefit derived by the counties from river regulation. And fairly consistent with the current apportionment process, at least for the hydroelectric facilities. We're proposing to use the actual head that's used by each facility, each hydroelectric facility, as part of the ratio to determine the percentage of benefit. That term being different from the apportionment. But I'll get into the differences a little bit later. There's a table at the end of the memo and attachment D, I believe it is, that details the hydro facilities that are downstream of the Stillwater Reservoir and of the Six Lake and Old Forge Reservoir. Differences being the facilities that are upstream of the confluence of the Beaver and Black River are not reflected on the Stillwater Reservoir table in attachment D, and similarly the Beaver River facilities, which are not downstream of the Moose and the Black River, are not reflected on the Six Lake and Old Forge summary table. Each table identifies the actual head used and the ratio of the individual facility to the total actual head of all, the sum of all of those facilities, thus producing a percentage of benefit derived. Very similar to the methodology we currently use for the Black River area. The other portion of this section that's been added to the memo details and outlines the calculation of the benefit derived by the various counties. The methodology that we proposed was similar to what we used in the Hudson River area. It includes a tabulation of the value of real property, market value of real property immediately adjacent to the rivers, and summed by municipality and then by county, with each county's portion of benefit represented by the value of the property adjacent to the rivers as the numerator in the ratio, and the denominator being the sum of all of the properties that are included in the calculation. And that draft percentage of benefit derived is shown in the last table in attachment D.
On page 38 of the board packet.
And at this point it is a draft, but again, for the counties, the percentage of benefit derived, which is the ratio of the individual counties' real property values, the value of the real property in each county, divided by the value of all the county's properties. This preliminary calculation, we determined Hamilton County to have about 2.26%, Herkimer 19.86%, Oneida 1.61%, Lewis County at 28.1%, and Jefferson County at 44.5%, of the total percentage. That summing to 96.33, and the remainder, which has been removed from the calculation for across all of the counties, is the state lands that were also adjacent to the river, which have been removed from the calculation process. Happy to answer any questions too, if you have any.
Questions?
Well, I know that the counties have been met with. I know you're doing it.
Three of the
You wanna
five.
comment-
Three of the five we have
You want
directly
to comment
set
what the
down.
reactions were to this, so that the rest of the board knows?
So we met with Lewis County, Hamilton County, and Jefferson County with the respective chairman of the Board of Supervisors of the legislative boards. We shared information with them regarding how the methodology would fall onto their counties, and then entered into general discussions with them about how the revenue would be raised by them to be able to meet the assessment. And they had a variety of different initial reactions when they saw the actual ratios and the proportions. We got positive feedback from the counties. Sort of different, I think, than what happened in the Hudson River area.
So is this new for the 5 counties in the Black River area to be
Correct,
contributing?
Oh, yeah.
correct.
And they take this positively?
Their initial reaction.
More resignation than it
It's a
was.
certain way to characterize
Right.
it.
I think the concern was more that, oh, you're doing it this year and this is our budget year.
Right.
We're already in our
Timing was a,
budget year.
right, timing was, I think, the
The timing
principal
was more
concern.
the issue than.
I think if I may, I think the reaction that we received had a lot to do with some of the estimates that we provided them. So Mr. Fulton got into the proportion percentages. We also ran them some general ballpark estimates as to what that assessment in dollars might look to each of the counties. I think once we got to that aspect of it, which is really for them the bottom line, I think that went a long way to mitigating their concern in terms of it not being this enormous amount of money that they needed to recoup from, their own county tax base.
So what was the general estimate
So the general,
monetarily?
so if we look at the assessment today, or the apportionment today, we decided, we thought it was the best approach to use the proportion of the assessment across the hydros, which currently, as of today and for the cycle that we've currently been in, represents almost 96%, if my numbers are right. 94.1% of the entire apportionment and resulting assessment. That left 5.8% that is a result of removing predominantly undeveloped head and principally Niagara Mohawk from the assessment. So that 5.8, so if you looked at just the apportionment dollars today, that 5.8% factoring in the state share that's already been established at $250,000 a year, you would get a total estimated amount to assess or apportion among the 5 counties at somewhere around $57,000 to $58,000. You multiply 44%, the largest on here for Jefferson County, times that number, and you're in the 20,000 something range, and down to the 1% that is for Oneida County, you're at an even very small number. So I think those numbers, those estimates, went a long way to the reaction that we received. And timing, again, seemed to be the biggest concern.
And I think another point is that with the closing of the litigation, the counties are now able to go back for some of the properties that they had not been able to collect upon, to go back to those entities and collect their normal property taxes, which had been held up. And that was, for them, that was a significant
That was-
part of this
right.
resolution.
Correct, good point.
No, I know a lot of work went into getting this all together. You presented it very simply, but I have
Sure.
some idea of the scope of work that went into this.
There's-
To the whole staff, and congratulate the staff for getting this done.
There's two other memos pertinent to the timing, really. One had to do with the apportionment grievance process. Basically, noting that once we have a beneficiary list, an apportionment methodology established, and an apportionment date, finally we determine the state share, then the board's going to be in a position to approve the apportionment. After they've done that, it then has to go to DEC for DEC's approval. After DEC's approval, then pursuant to the regs we adopted as part of the Hudson River area apportionment, which are still in effect, we have to provide any aggrieved party, probably the counties, but maybe the hydros as well, or anybody else that decides they want to chime in, with 45 days notice for them to create their arguments. They then give us about a week's notice so that we know what their grievances are, and then they come and present those to the board. After that, the board either determines to modify the apportionment based on those grievances or not modify it. If they don't modify it, it's done. It's a final document. If they do modify it, it then has to go back to DEC, and with DEC then determine whether those modifications are so material that a new 45-day process in grievance hearing is required. Probably won't be, but that's the process. So once you guys determine the apportionment, we're still a ways away from completion of the process.
I assume the parties have an Article 78 right?
At the end, once the apportionment is final, that finality triggers their opportunity, anybody who's aggrieved by it and has standing, triggers their opportunity to bring an Article 78 within essentially 4 months,
4 months.
of the date it becomes final.
What's an Article 78, just?
Article 78
Oh,
is
sorry.
the Civil Practice Law and Rules of New York State, which is a statute, gives any entity aggrieved by an administrative decision an opportunity to go to Supreme Court in a relevant county to challenge that administrative decision. Your apportionment determination, as approved by DEC, would be that final agency or administrative decision that is challengeable in state court pursuant to Article 78 of the Civil Practice Law and Rules, which lay out the process for that kind of a
Okay.
And, Rob, I think I'm still correct me if I'm wrong, to allay some concerns about that. I think the only basis for successful challenge is if the agency's decision is arbitrary and capricious
Right.
and or without basis in law.
yes.
So with all the
So
homework,
as,
in other
so
words,
as long
that's
as
been
we
done.
have,
Right.
as long as we have memos backing up everything we're doing, a basis for determining who's in, who's out,
Which we do.
which we're developing as we go. The initial question, why are we doing this, is pretty simple. The memo that I handed out to you today kind of outlines the basis that staff believes supports the board's decision to go forward. We had an audit done by the state comptroller, and in that audit, the state comptroller said you're not able to collect some of the monies that you have been assessing under the existing apportionment. You really ought to write those off. We wrote back in our response to that audit saying you don't understand our statute. Statute requires that we reapportion those costs among the entities that are benefited. And then, based on our understanding of our need to do an apportionment, we settled the Niagara Mohawk case, and as part of that settlement, agreed to take Niagara Mohawk out of the existing apportionment. And because they're out, we need to reapportion
Yeah.
among those that remain or determine a new set of beneficiaries to take the apportionment. So those two tenants support the board's decision to go forward with the apportionment at this point.
Very good.
Has anything ever been levied against the counties in the Black River area before?
Not
No,
from the
no.
regulating district.
Okay, just curious.
If I compare, I was at one meeting. The concern was more about this tax year as opposed to future.
Right.
I think that was the big concern
Yeah,
that we're.
similar concern was raised at the end of the Hudson River area apportionment. We came, in that case, we came to a negotiated settlement with the counties, and one of the counties, as part of that negotiation, said, you know what, we just can't swing it. We can't do this by the October 31st date that you want us to pony up this big chunk of money. And we were able to agree that we would make the assessment due October 31st. We would not begin to assess any penalty until they had an opportunity to pass their next fiscal year, which in that case was January 1st. I suspect each of these 5 counties that we're facing are going to be in the same boat. And by the time we get this apportionment done, DEC approves it, you guys go through with your apportionment grievance hearing, you make any minor modifications, DEC approves the minor modifications, and we set the date by which the payments are due, we're going to be able to push it off and defer to Rick as to whether fiscally we have the money to float them until their next fiscal year. My guess is we're probably going to be able to address that concern.
Okay. Need a motion to adjourn?
Sure. Yeah.
Motion to adjourn?
Second, all in favor? Aye.
Aye.